Privacy has become an increasingly important aspect of online life. In a recent survey, almost 3/4 of US consumers believe privacy laws are not good enough. As greater amounts of personal data are generated, regulations evolve to protect the privacy rights of the individual. Two of the most well-known data privacy laws are the EU's GDPR, General Data Protection Regulation, and the Californian CCPA, California Consumer Privacy Act. These two regulations have stringent requirements on how personal data is used, shared, consumed, analyzed, and stored. Both regulations are now several years old. Here we explore where these laws converge and where they diverge, and some of the latest developments in the world of data privacy as seen through the lenses of the GDPR and CCPA. In answer to the question, are the GDPR and CCPA the same? The simple answer is in some ways yes. The CCPA is sometimes described as GDPR 2, but differs in the details and the scope of the law. The CCPA has also been criticized for being less stringent than GDPR. However, the CCPA is being updated to address some of the criticisms. To understand where the two regulations converge and diverge, the devil in the detail needs to be explored. Data types are similar for CCPA and GDPR. However, CCPA has in scope personal information that can be used to track, link, and identify an individual consumer or a household. The CCPA covers data entered in online forms or collected by tracking cookies or similar. The Act lists the data covered and includes name, social security number, address, etc. GDPR has in scope personal data that identifies, describes, or is associated with a data subject, individual. Includes categories for personal and sensitive data. Personal data includes name, address, date of birth, etc. Sensitive data includes health data, biometrics, religious beliefs, etc. When 3 data elements are identified, the ability to uniquely identify a person is 85%. With 4 data elements, it is almost 99%. How do they converge or diverge? They are very similar. The CCPA does not specify different requirements for sensitive data. However, there are requirements that preclude the use of data to discriminate. The CCPA defines data linked at the household or device level. Let's look at data rights. Data rights for CCPA include the right to opt out, the right to have notice, also known as the right to be informed, the right to disclosure, the right to deletion of their data, and the right to equal services and prices. Data rights for GDPR include the right to be informed, have access, rectification of their data, erasure of their data, to restrict processing, data portability, and object to data processing or other activities. How do they converge or diverge? They are similar, but GDPR goes further in the right to object to data processing, especially for automated profiling purposes. The CCPA has consumer rights at its heart, so has a right to equal services and prices. In terms of geographies, CCPA covers California residents and is global in scope, since any business that carries out a data transaction involving a California citizen is affected. GDPR covers EU residents and is global in scope, since any business that carries out a data transaction involving an EU citizen is affected. How do they converge or diverge? Both have global implications even though they are designed for specific geographies. In terms of organizations, which are defined as businesses in CCPA and data controllers in GDPR, CCPA applies to for-profit organizations that do business in California. It also has a provision for service providers, which are organizations that process personal information on behalf of a business. For CCPA to apply, a company should have gross revenues over $25 million or buy or sell the personal data of 50,000 plus California consumers, households, or devices per year, or receive more than 50% of annual revenue from selling California consumers' personal data. GDPR defines data controllers as organizations that process personal data and processors as organizations that process personal data on behalf of controllers. There are some derogations for companies with less than 250 employees, mainly around reduced documentation and reporting requirements. Further details can be found in Article 30 of the GDPR. How do they converge or diverge? GDPR has a wider scope and includes all organizations, but with some derogations for size. What about the consumer rights for CCPA versus the data subject rights for GDPR? CCPA applies to California residents even if they are transacting outside of the state. The CCPA refers to people as consumers and uses the term household. GDPR applies to EU residents. The GDPR refers to people as data subjects. How do they converge or diverge? Both cover children, but the GDPR has a wider scope for parental consent, applying to all data processing consent requests. What about technology requirements like pseudonymization, anonymization, encryption? CCPA uses de-identified or aggregated data as the baseline technological measure. However, there are stringent definitions on how this is achieved. GDPR only allows anonymous data to be exempt. How do they converge or diverge? Both require technical controls such as encryption and robust authentication. What about opting in or opting out? CCPA requires businesses to show privacy notices with an explicit opt-out option. GDPR, by default, there is an explicit opt-out by data controllers when collecting personal data. How do they converge or diverge? Both are similar, but the CCPA notice requirements only cover 12 months after the request. What about breach notification? CCPA breaches must be reported to the California Attorney General within 72 hours of noticing the breach. For GDPR, a data controller must report a personal data breach to its local supervisory authority within 72 hours of becoming aware of the breach, if it is likely to result in a risk to the rights and freedoms of individuals. How do they converge or diverge? Both are very similar. Lastly, let's look at fines. CCPA has a maximum charge per violation of $7,500 for intentional violations or $2,500 if non-intentional. GDPR has up to 20 million euros or up to 4% of a company's global annual turnover, whichever is higher for data subject-related events, and 10 million euros or up to 2% of annual turnover, whichever is higher for data breaches. Recently, Amazon was fined $887 million for the use of data for targeted marketing. How do they converge or diverge? CCPA fines are lower than GDPR. However, the latest update to the CCPA may change this. What's new in the world of GDPR and CCPA? Privacy laws reflect the status of technology and consumer expectations. As such, these laws tend to change over time. Some updates to the CCPA and GDPR are: the latest update to the CCPA, the California Privacy Rights Act, CPRA, sometimes called the CCPA 2.0, brings new requirements into play. This update will come into force on January 1, 2023. Changes include a threshold increase in the number of consumers whose data is processed from 50,000 to 100,000. The update also includes more stringent consumer rights that are more in line with the GDPR. Enforcement of GDPR is increasing in pace and moving from breach notification fines to fines for non-compliance with data rights and the legal basis for processing. New legislation is also entering the landscape. As example, NIS2, the Network and Information Security Directive, DGA, the Data Governance Act, and the EPR, the e-Privacy Regulation, are evolving regulations. These regulations bolster and augment GDPR requirements. Let's look at data transfers between the EU and the US. Cross-border transfers of data are a complex area, even if both sides have equivalent privacy laws. Data transfer is increasingly a global issue, and can cause business bottlenecks. To alleviate this, jurisdictions create legal frameworks to help data movement flow. Data transfers between the EU and the USA are covered by EU standard contractual clauses, which came into force in 2021. These contracts are used to cover the complicated legalities of the transfer of personal data from the European Union to third countries. Privacy regulations the world over reflect the massive amounts of personal data collected, shared, transferred, analyzed, and stored by businesses. These regulations are legal requirements, and if a business comes under the umbrella of privacy law, it must comply or face large fines. Even seemingly local laws such as CCPA can have global repercussions because businesses often act globally. But privacy is not just about avoiding fines. Our customers want the respect for their privacy. As a McKinsey insight, the consumer data opportunity and the privacy imperative found out, consumers trust companies that limit the use of personal data and respond quickly to hacks and breaches. The march of privacy continues with new state laws expected to come into force in the USA in the coming 18 months. The new tech era of the metaverse and Web 3.0 will ensure that privacy laws like GDPR and CCPA will continue to change to reflect these paradigms. Keeping pace is now an integral part of doing business the world over.